You're 2 weeks from closing on your Iowa home. Everything's on track. And then your attorney calls and says there's a problem with the title. If you've never been through this, it's terrifying because suddenly the deal you've been planning around, the moving truck, the new school, the whole next chapter is in jeopardy. I'm Jeremy Danilson, a real estate attorney in Iowa. I review abstracts of title and write title opinions for a living. And in this video, I'm going to walk you through the 5 most common title problems I find in Iowa transactions, what causes them, what they mean for your deal, and how to fix them. If you're buying or selling a home in Iowa, this is the video that keeps you from being blindsided at the worst possible moment. Let's start with the one I see the most. Problem number 1, unreleased mortgages. Here's a scenario I deal with constantly. The seller refinanced their home 3 years ago. They paid off the old loan. They've been making payments on the new loan ever since. Everything's fine, right? Except when I read the abstract, the old mortgage is still there. The lender that was paid off never filed a release of mortgage with the county recorder. So according to the public record, that old loan still exists as a lien on the property. This is incredibly common, and it's almost never the seller's fault. The seller did everything right. They refinanced. The old loan was paid, but the lender dropped the ball on the paperwork. To fix it, we have to track down the original lender and get them to file a release. If that lender has been acquired by another bank, which happens all the time, we're now dealing with a company that has no record of the original loan and an overwhelmed back office. I've seen this take anywhere from a few days to several weeks. The lesson for sellers: if you've ever refinanced, check with your attorney early to make sure all prior mortgages show as released in the county records. Don't wait until the buyer's attorney finds it in the abstract 2 weeks before closing. Problem number 2, judgment liens. In Iowa, when a court enters a judgment against you, that judgment automatically attaches as a lien against any real property you own in the county where the judgment is entered. And in many cases, it can attach statewide. So maybe you had a credit card lawsuit 5 years ago. You worked out a payment plan, you paid it off, life moved on, but nobody filed a satisfaction of judgment with the court. That judgment is still showing up in the abstract, and it's still attached to your property as a lien. Or here's one that surprises people. You don't even have to be the one who was sued. If there's a judgment against someone with the same name as you, or even similar, it can show up in your abstract. We call these name hits, and they have to be investigated and cleared. To resolve a judgment lien, we need a satisfaction of judgment filed with the court, or we need to demonstrate that the judgment belongs to a different person, or we need to show that the judgment has expired under Iowa's statute of limitations. Problem number 3, child support liens. This one catches sellers completely off guard. Under Iowa Code Section 624.23, child support orders automatically become liens against real property, and each monthly payment that comes due creates a new lien that lasts for 10 years from that due date. That means if you have an active child support obligation, there are potentially dozens of individual liens stacking up against your property, one for every month. Here's the thing. You don't have to be behind on payments for the lien to exist. The lien attaches automatically by operation of law. So a seller who has been current on every single payment still has these liens affecting their property. They just need to be cleared before we can transfer clean title. So how do we clear them? There are a couple of paths. First, we can get an affidavit from the person receiving the child support, the payee, verifying that the payor has been current on their obligations. That affidavit goes into the record and satisfies the title requirement. Alternatively, we can obtain certified payment records from the Child Support Recovery Union. An attorney reviews those records and provides an affidavit confirming that payments are current based on that review. Either way, the process takes time, and it can be uncomfortable for sellers who aren't expecting it to come up. I want to be clear about this. It's not a reflection of your character. It's a legal mechanism that applies to every child support obligation in Iowa, regardless of whether payments are current. We handle it professionally and confidentially. Problem number 4, defective deeds. A deed is defective when it contains an error that calls the validity of the transfer into question. And these errors are more common than you'd expect. The single most frequent defect I see is a missing marital status. Iowa law requires that a grantor seller's marital status be stated on the deed. If it's missing, the title examiner has to ask, was this person married at the time they signed the deed? Did the spouse need to join in the conveyance? Because if the grantor was married and the spouse didn't sign the deed, there could be a dower or homestead interest that wasn't properly released. That's a serious defect. And that leads to the second most common issue, a spouse failing to join in the conveyance. In Iowa, if you're married and you're selling homestead property, your spouse has to sign the deed. If they didn't, the deed may not have effectively transferred the full interest. This comes up constantly in older abstracts where the norms around deed preparation were less rigorous. Beyond marital status issues, I see misspelled names. The deed says Jonathan, but the seller's legal name is Jonathan without an H. I see wrong legal descriptions. A deed that references the wrong lot number or that transposes numbers in the section, township, and the range description. I see vesting language errors. The property was supposed to be held in joint tenancy, but the deed created a tenancy in common. Every one of these defects requires a corrective deed. And here's the complication. A corrective deed requires the cooperation of the people who signed the original deed. If the original grantor has passed away or moved out of state, or simply doesn't want to cooperate, resolving a defective deed could get significantly more complex. This is why deed preparation matters. When I prepare a deed for closing, I verify every name against official identification. I confirm marital status and make sure the spouse joins in when required. I confirm the legal description against the abstract and the county records, and I make sure the vesting language matches the buyer's intentions. Getting it right the first time prevents this problem from showing up in someone else's abstract 10 years from now. Problem number 5, boundary disputes and survey issues. This one is different from the others because it usually doesn't show up in the abstract itself. It shows up when the buyer gets a survey or when the title opinion reveals an easement or encroachment that wasn't expected. Maybe the neighbor's fence is 2 feet over the property line. Maybe the seller's garage was built partially on an easement. Maybe the driveway that the seller has been using for 20 years actually crosses the neighbor's property. These situations are tricky because they can't always be fixed with paperwork. A boundary dispute might require a survey, a boundary line agreement between neighbors, or in worst cases, litigation. An encroachment on an easement might require the easement holder's permission to stay, or it might mean the structure has to be moved. For buyers, I always recommend getting a survey, especially if the property is older, rural, or if the lot lines seem unusual. The cost of a survey is a fraction of the cost of discovering a boundary problem after you've already closed. So those are the 5 most common title problems I see in Iowa transactions: unreleased mortgages, judgment liens, child support liens, defective deeds, and boundary disputes. Here's the good news. Most of these problems are fixable. They take time and legwork, but with an experienced attorney working on them, the vast majority of title issues get resolved well before closing day. The key is timing. The earlier your attorney reviews the abstract, the more time there is to fix problems. If the abstract doesn't get to the attorney until a week before closing, a routine issue could become a crisis. If the attorney has the abstract 4 or 5 weeks before closing, even a complicated title problem can usually be resolved without delaying the deal. This is exactly why I tell every seller, get your abstract updated the day you accept the offer. Don't wait. Don't assume the title is clean. Let your attorney review it early so there's time to handle whatever comes up. And for buyers, make sure you're working with an attorney who is thorough. The title opinion is the document that protects your investment. You want an attorney who reads every page of that abstract and flags every issue, not one who skims it and hopes for the best. If you're buying or selling a home in Iowa and you want an attorney who takes the title review seriously, reach out to my team at Danilson Law. Link is in the description, and if you found this helpful, please hit subscribe. I put out Iowa-specific real estate content every month.